Um, Welcome to everyone who's joined us both in person and online. This is the 18th Human Rights in Asia conference, and it has been a privilege to greet you this morning to formally open our proceedings. For nearly 2 decades, this conference has served as a vital, dynamic platform. Year after year, it has brought together scholars, practitioners, and passionate advocates to confront the most pressing human rights challenges across Asia. When we first began laying the groundwork for this year's event, we knew we had to choose an issue and confront an issue that touches every aspect of our modern lives. And over the course of the next 7 days, starting today, we'll be navigating our central theme, which is human rights, technology, and development. So, technology is no longer just a tool, it is the very infrastructure of our societies. It shapes our economies, our governments, and our personal freedoms. Yet, while technology and innovation holds immense potential to drive development and empower communities, we are acutely aware that this progress is not inherently equitable. Without careful rights-based governance, technology threatens to deepen existing societal fault lines. And to frame a understanding of these massive shifts, we're incredibly privileged to feature a keynote address from Dr. Bumsuk Beg, an expert in this field and a member of the advisory committee to the UN Human Rights Council. His extensive expertise and vision will perfectly set the stage for the rigorous discussions we have planned for you today. The first panel discussion we have planned today is the Gender Discrimination and AI panel. As algorithmic decision making and artificial intelligence become deeply embedded in everything from hiring practices to judicial systems, we face the alarming reality that these technologies often inherit and amplify historical biases. To challenge us on how we ensure the algorithms of the future do not merely automate the discrimination of the past, we'll be hearing from an outstanding lineup, including Dr. Jamie Stewart, Sarah Yunmi Tay, and Jyoti Vadera. Following that discussion, we will transition to a deeply related challenge, which has become abundantly clear over the years, which is that the gap between the digitally connected and the disconnected is one of the defining human rights crises of our time. The expanding digital divide is not merely about who owns a smartphone, it is also about who gets to participate in the modern economy and whose voice is heard in the digital public square. We'll be honored to have Professor V.C. Vivekanandan guiding this panel later, and he will be bringing his invaluable insights into how systemic digital exclusion impacts fundamental rights. Pulling an event of this magnitude requires tremendous collaborative effort, and I would like to thank the entire organizing team for their resilience over the last several months. And to all our speakers who will be sharing their wisdom, thank you for your commitment to this cause. To officially set our agenda in motion, I'd like to introduce and invite Dr. Carla Fussman, Director of the Human Rights Center at Essex University, University of Essex, to open the conference. I think you do either. There's the microphone.
Good morning, everyone. A warm welcome to everyone who is here with us in the room and also those who are joining online. It's a really special event this year and every year. This student-led conference has been going for 18 years. We're delighted that there's so many things to share, that we have such interest and such a great student group each year, including this year, to lead us in finding the most exciting, innovative, and important issues to discuss about human rights in Asia. My special thanks go to Dr. Sane Fujita. Thank you. Thank you, Dr. Fujita, for being at the forefront of this conference since the very start. Without you, we would have not had the momentum to continue with this important event from the very beginning. And we welcome the fact that you are willing to share with the students, to share with all of us your expertise in bringing human rights to Asia to fruition. We have a great group of students this year, and I thank every single one of them for their involvement in bringing these issues to the forefront. And we have a great agenda. I'm really grateful to all the speakers who have agreed to take time out of their busy schedules on a Saturday to come to share information and to ensure that we can all learn from their expertise. So thank you to everyone. On behalf of the Human Rights Center, these proceedings are open, and I'm going to turn now to our next guest, which is Dr. Sane Fujita.
Thank you, Dr. Kala, and welcome everyone from many different countries and in the room. And I especially thank the speaker who made the effort to find time to prepare the presentation and join us this morning. Well, maybe not morning in your country, but this is early in the morning, Saturday in the UK. And I've been, as Dr. Kala mentioned, that I've been guiding students to organize this important topic, important conference over nearly, more than 18 years or something. So I'd like to briefly introduce the background of this conference and a bit of introduction to this this year's topic. Essex Human Rights Asia Conference is a student-led flagship event of Essex Human Rights Center. As you see, population inside of the Circle Asia region is much bigger than the rest of the world. So this is a very populated region. However, the commitment to human rights is not very great. So we have a lot of human rights issues. However, because of lack of the regional mechanism in Asia Pacific region, this region is kindly neglected in the human rights course entirely. So students stood up in 2009 and we started this conference, small one in the beginning, but little by little, it became bigger. And so now, each year students decided different topic, which is very timely and important topic, depends on the situation of the world. And the students are not only from Asia, but from all over the world. And from 2020, because of the COVID, we switched to online last few years. But since last year, we changed to hybrid. So it's great to have students in the room. And this was last year. And we're going to discuss the technology and human rights. And I really appreciate the Human Rights Center, Dr. Kala, and the conference team and to support us. And especially I congratulate the student who made a lot of effort to make this happen last few months. I really I feel really proud of you guys. They work so much. So and then before I hand over to the speaker, I've been thinking of this topic in my life. I just came back from Japan, and then more and more restaurants in Japan, customers have to use smartphone to order food like this, and your order come by brought by this robot. And if you are able to use this, it's okay. But thinking about my parents who use just smartphone as a phone, maybe cannot do this. So they can use this kind of restaurant. Of course, they can go to other restaurants who take order without this technology. But what happens if this happens in the hospital, social welfare system, or banking? So it's a bit difficult for them. That's something I've been feeling that. The other thing is, I've been working with expert and working for human rights in Japan. That's more than 10 years. In 2015, we had a country visit by UN Special Rapporteur on freedom of expression. I supported his mission entire time. Then after that, we discovered that we've been under surveillance by the government entire mission. So this is not just a tricky country, but Japan is no exception. There's threat to the human rights defender. Then now the government is organizing the drafting bill on prevention of espionage and other activities related to state security. So, and of course, they are utilizing the technology to monitor people as much as possible. So, is there a risk to the freedom of expression or risk to survey ordinary citizen, especially the activists like me? So, this is a kind of thing which we can think about. So, thank you very much. And please don't forget to register. We have day 2 and day 3 as well. So enjoy today. And I'd like to hand over to whoever it is. Thank you very much.
Thank you very much, Dr. Fujita and Dr. Horstman. So now we want to invite everyone to jump into the discussion on human rights technology and development. Our keynote speaker, Professor Beck, will navigate you. Professor Bensuk Beck is a leading authority in international law and human rights. He is a professor at Kyunhee University Law School in Korea. Currently, he serves on the advisory committee of the UN Human Rights Council and the Sentencing Commission of the Supreme Court of Korea. In 2021, as a rapporteur, he submitted a report, Possible Impacts, Opportunities, and Challenges of New and Emerging Digital Technologies with regard to the promotion and protection of human rights to the UN Human Rights Council. He is currently preparing a report on the impact of artificial intelligence on good governance. Everyone, please welcome Professor Beck. Professor Beck, please.
Thank you. Thank you for the introduction. Good morning and good evening from Seoul. It is a great honor to be invited to speak at the 18th Annual Human Rights in Asia Conference at the University of Essex. I sincerely appreciate this valuable opportunity, and I would like to express my gratitude to the student organizing team for the effort in putting together this conference, and also to Dr. Fujita for kindly recommending me for this presentation. I'd like to share my presentation file. Can you see the file?
Yes, we can see your presentation file.
Okay. So today's conference theme, human rights, technology, and development directly shape my presentation. The conference lightly draws our attention to what has been called the connectivity paradox, the tension between the promise of technological advancement and the reality of deepening inequalities. I hope that the 7 propositions I will present today can serve as a foundation for the sessions that follow on gender discrimination and AI, and as well as the expanding the digital divide. While technological paradigms have evolved dramatically, the UN has long engaged the human rights implication of scientific and technological progress. As a table on this slide indicates, from the post-UDHR period onward, the organization has repeatedly returned to the same core question: how to enable innovation's benefits while safeguarding rights. This reminds us that new technologies are recurrent feature of each generation, not a novelty of current era. And especially the UDHR Article 27 and ICSCR Article 15 frame the normative baseline. read together, they require that the gains of digital innovation be accessible and beneficial to all, with safeguards that preserve dignity and equality. As those benefits are realized, which will undergird the rest of my remarks. I will present 7 core propositions that capture the most crucial insights from 3 decades of UN work on digital technology and human rights. These propositions emerge from the extensive body of the work, over 120 UN documents, including General Assembly and Human Rights Council resolutions, OHCHR reports, and special procedures findings. This volume of documentation tells us something important. The digital technology and human rights have moved from periphery to the center of UN human rights agenda. This trajectory becomes particularly clear when we focus on the biannual resolutions of the Human Rights Council, specifically dedicated to new and emerging digital technology and human rights, which I joined as a rapporteur. The first resolution, 31/11 in 2019, explicitly affirmed that digital technologies embedded values and biases requiring normative oversight. It mandated the advisory committee to conduct a comprehensive study, and our report identified 7 categories of human rights challenges posed by digital technologies. Remarkably, these challenges have not been mitigated, but rather amplified with the emergence of artificial intelligence. Then in 2021, the second resolution, 47/23, fully applied the UN Guiding Principles on Business and Human Rights to the tech sector, emphasizing both state duties to protect and corporate responsibilities to respect human rights. And the third one in 2023 marked unprecedented, specifically identifying unacceptable risks in certain AI applications, signaling that some usages may be fundamentally incompatible with human rights. It mandated human rights impact assessment, due diligence, algorithmic transparency, and effective remedies. And most recent resolution 59/11 adopted last year in 2025 shifted focus to implementation, calling for integrated guidelines and marking a crucial transition from norm setting to actionable measures. These resolutions trace an evolution for the 7 key points I will share today that offer direction as we confront the human rights challenges of AI. My first point is that technology is not neutral. Often we hear a phrase like guns don't kill people, actually people do, implying that the tool is blameless and only its user's intention determine the outcome. In the context of AI and digital technology, I believe this reasoning is flawed. The UN human rights discussion have explicitly cautioned that assuming technology is neutral and that the negative impacts are solely due to human misuse actually oversimplifies the situation. Not only can users abuse technology, but technology itself can restrict rights and freedoms. Think about algorithm decision-making systems. If an AI tool used in hiring or criminal sentencing is trained on biased historical data, it may systemically discriminate against certain racial or social groups. No one at the point of use may intend to discriminate, and yet the outcome is biased. The bias was embedded in the technology itself. Overall, we must move beyond the myth that it's all about how we use it. My second point is that we do not start from scratch when it comes to human rights in the digital age. Our existing international human rights norms are not obsolete. On the contrary, they must be our first line of defense and guidance for new technologies. The UN and many governments have made it clear that international human rights law applies equally online and offline. What does this mean in practice? It means that rights enshrined in the ICCPR, like the right to privacy, freedom of expression, freedom of association, right to a fair trial, all these apply to digital activities and technologies. Similarly, economic, social, and cultural rights also apply when those services are delivered by AI. In other words, before we invent new norms, we should fully implement what we have. Our existing human rights norms are powerful enough if used properly in digital context. This approach prevents us from using technology as a justification to weaken existing rights. Rather, our existing human rights framework must shape and constrain how we design and implement new technologies. The third point is that safeguarding human rights in relation to AI requires a life cycle approach. What do I mean by life cycle? It means we must take action at each phase of technology, creation and use, design, development, testing, implementation, operation, and even disposal. Human rights consideration should not be an afterthought, but they should be built in from the very beginning and revisited continuously. Practically, a life cycle approach can be implemented through tools like human rights impact assessment or similar due diligence process, much like an environmental impact assessment. This idea is gaining traction. Indeed, the UN Guiding Principle on Business and Human Rights and follow-up initiatives like OHCHR's Big Tech project encourage tech companies to conduct human rights due diligence on their products. Importantly, a human rights lens throughout the life cycle helps protect vulnerable groups. As we design technology, we must include consideration for those who are often marginalized: women, children, persons with disabilities, racial or ethnic minorities. Overall, a proactive end-to-end governance approach is needed. This is the only way to ensure AI truly remains a tool for good. The first point I want to raise is the concerns of business context in which AI and digital technologies operate. Specifically, we need to talk about surveillance-based business models. Under this model, services like search, email, or social networking are provided to billions of users and no direct financial cost. Instead of paying with money, users pay with their personal data. Every time we use these free platforms, the tech companies is recording our actions, what we search for, whom we message, which posts we like, where we go with our phones, and so on. All these data is aggregated and analyzed using AI and big data techniques. The goal is to predict our behavior, to figure out what we might buy, who we might vote for election, what will keep us engaged, and then to sell those predictions to advertisers or other third parties. This targeted advertising business generates enormous profits. And as a result, a small number of tech companies have accumulated unprecedented economic and social power. In a 2022 report, the UN OHCHR, Office of High Commissioner for Human Rights, stated that the most serious human rights risks in the tech sector are inherent in the business model. not just in a supply chain. This means that as long as a company's profit hinges on surveilling users and monetizing their personal data, there will be a structural tension with privacy and other rights. For years, this model grew in a regulatory vacuum. Governments in the US, Europe, China, and even Korea often deferred to tech companies, believing that too much regulation would stifle innovation. So big tech companies have massive power, but minimal accountability, and indeed we live in an age of irresponsibility, where society expected little oversight over their data practices. My fifth point addressed the twin gaps we face, the normative gaps and operational gaps, and why international cooperation is crucial to bridge them. Let's unpack these concepts. Firstly, the normative gap refers to the disconnect in understanding and frameworks between the tech sector and the human rights community. On one side, we have software engineers, data scientists, AI developers. And on the other side, we have jurists, lawyers, and human rights advocates. Each group has its own language and perspective. It's perhaps not surprising at all that a brilliant AI engineer might not be well versed in, say, the UN Convention on the Rights of the Child, CRC, or that the human rights lawyer might not fully understand how an algorithm processes data. But this gap is dangerous. It means that new technologies are often developed without human rights expertise at the table. At the same time, regulators sometimes lack technical insight. Such an expertise divide can result in a paradoxical situations, the so-called human rights trade-offs. Secondly, the operational gap concerns timing and scope. Law and policy move slowly, and technology moves very quickly. We are always playing catch up. By the time law regulating, say, facial recognition is debated and passed, the technology might have already proliferated into new domains. There is inherently an inevitable time gap between technological innovation and the development of corresponding legal norms. This time lag is not just a domestic problem, it's international. We now have some countries forging ahead with their own AI regulations, while others have nothing in place. If each nation or region set different rules, we could end up with overlapping or even conflicting regulations. This is why I stress the need for international cooperation. The global transnational nature of digital technologies means no one country can effectively govern all the impacts. My sixth point is a caution about the global power dynamics of technology governance. We are at a juncture where rules and norms for AI are being formulated. However, who gets to decide these rules? Currently, a relatively small group of nations and companies are at the forefront. US and China, for example, are AI superpowers in terms of investment, patents, and deployed systems. EU, European Union, while not a dominant in the industry, is taking a leading role in regulation with its AI Act and data protection laws. It often experts a brutal effect of standards. Large multinational tech companies such as Google, Microsoft, Meta, and OpenAI are also de facto setting norms by their platforms, which and their own AI ethics initiatives. The problem is that many other countries and communities feel left out of these processes. There is a growing discourse on digital colonialism, which essentially analogizes modern tech dominance to the old colonial order. This can take the form of technical standards that don't account for diverse languages or social norms, or policy frameworks that don't address the need of developing nations. AI language models and speech recognition systems perform much better in English and a few major languages than in thousands of other world languages. This is because the data and research have been Western-centric. As a result, speakers of less resourced languages are at risk of being digitally marginalized. That is, their language is not recognized by tech, their content underrepresented. That's a form of digital inequality rooted in a historical inequality, injustice of resource and attention. From a governance standpoint, if only a few governments create the rules, these rules might prioritize their interests. For instance, a powerful state might prioritize rules that protect its tech companies' intellectual property and market access, rather than rules that protect individual users' human rights globally or help smaller nations build capacity. The remedy is inclusive and multipolar governance. We need broad representation in international fora that discuss AI, not just the G7 or OECD countries, but also the voices of Africa, Asia, Pacific developing states, and others who are too often on the periphery of these debates. Digital colonialism is not inevitable, but avoiding it requires conscious effort to democratize the setting of rules for AI. That includes capacity building and helping all countries develop expertise in AI and human rights so they can participate meaningfully. It includes multi-stakeholderism, including civil society from various regions, not just governments. The seventh and final point I want to highlight is deeply rooted in human rights tradition. Article 27 of the UDHR declares that, as I already pointed out, everyone has a right to share in scientific advancement and its benefits. Similarly, Article 15 of International Covenant on Economic, Social, and Cultural Rights obligates states to ensure that the benefits of scientific progress are enjoyed by all. This is sometimes referred to as a right to science or the right to the benefits of science. Why bring up this right in the context of AI? Because technology should serve every human being, as the UDHR clearly puts it. It's not enough to prevent AI from violating human rights. We should also strive for AI to actively advance human rights and well-being. If we treat the right to benefit from scientific progress seriously, we are compelled to address issues of access, inclusion, and equity in the AI space. Consider what it means in concrete terms. The digital divide, that is the gap between those who have access to digital technologies and those who do not, becomes a human rights concern under Article 27 of UDHR. It's not acceptable that entire region or communities are left behind in the AI revolution. Therefore, we must prevent technology from deepening existing inequalities. Another aspect of Article 27's wisdom is its emphasis on scientific advancement and its application being something to share. In today's terms, that could mean open collaboration in AI research, capacity building for developing countries, technology transfer where appropriate, and robust international support to ensure developing and least developed countries are not left out of the AI age. I argue and reaffirm that our task is to implement and extend such existing rights to science into new and emerging digital technologies, including AI. This is about continuity of our fundamental values. The UDHR's promises, equality, dignity, and rights for all are timeless. AI is just the newest arena in which we must fulfill those promises. It is not AI that needs ethics. It's a society. In the same way, the challenge is not to invent new rights for AI, but to ensure that AI development and deployment respect the human rights we have already established. In conclusion, let me tie these 7 points together and reflect on where we go from here. One thing is very clear, that is through the framework of human rights, we can and must shape the development and use of AI. Each of the 7 points reinforces that idea. Whether in discussing biased algorithm reflecting historical discrimination, or digital power imbalances echoing colonial patterns, we see that technology can inadvertently deepen existing inequalities rather than resolve them. However, as pointed out before, I want to leave you with a sense of optimism. These patterns need not persist in the digital age if we act with determination and learn from past mistakes. AI and digital technologies could become powerful tools for advancing human development and rights by identifying and counteracting biases, by empowering marginalized communities with new information and platforms, and by redistributing opportunities more equitably. And for this, we don't necessarily need to draft a new AI ethics for stretch. We have the UDHR guiding us already. The control of technology should be guided by the common good as defined by our human rights commitments. It has been a privilege to share these reflections from my nearly 6 years of work at the UN, and I encourage all of you as the next generation of human rights practitioners and scholars to actively engage with these issues. The governance of AI will be shaped by your generation more than any other. Thank you sincerely for your attention, and my appreciation go to the student organizing team for making this conference possible. Thank you very much.
Thank you, Dr. Baik. That was a wonderful introduction to a conference, and I'm sure everyone who is listening has taken a lot from your keynote speech. And I would like to ask people who are attending online as well as in person if anyone has any questions for Dr. Baik. We do have about 5 minutes, so if there are any questions, we can take them now. Yep.
Thank you, Dr. Baik, for a very exciting and interesting presentation. I wanted to ask you about the accountability frameworks. As you know, many of the companies who are leading on AI are so much bigger. They have a greater turnover than many states in terms of GDP. Can we really expect states to oversee or to have the capacity to develop accountability frameworks over companies which have so much power? At the same time, the UN guiding principles on business and human rights are not they're not binding as such. So they're quite limited. So I was quite curious what your thoughts were about the feasibility of accountability structures given the power imbalance with some of these companies. And then I had a second question, if there was time. With respect to the colonial impacts of the AI debate, one of the interesting positive developments is the extent to which countries and people from different parts of the world are being brought more into debates because of translation tools, online translation tools, which have increased many people's ability to engage in different kinds of ways with debates that would have never before been possible. Do you see any further scope in that area? So those would be my two questions. Thank you.
Thank you very much for the valuable question. Regarding the accountability, yes, as you clearly point out, the BHR, and the guiding principles are not legally binding tools, but at the same time, many countries are gradually adopt the legally binding domestic legislation related to BHR on the human rights due diligence. And even in case of Korea, the National Assembly recently submitted the bill on that. So I think as time goes on, there are more and more solid normative approach on that issue too. And at the same time, international law should not be restricted the traditional forms, the two dimensions. What I'm saying is that not only within the sovereign states, the internationally, how those transnational characteristics of AI and digital technologies can be bound by the international law. I think we need some new thoughts rather than the traditional approach on the international implementation of international law on that issue. Regarding the second question, translation, surely it can be helpful and it is desirable, but at the same time, still the data set itself are not enough to be reflected of the marginalized groups and indigenous peoples and so on. Even though it can be accessible through the technological development on translation, still the data itself is not reflected of those marginalized societies' views, their knowledge, and so on. Thank you.
Thank you, Dr. Vic. I think it's an excellent point you mentioned about the data set not being reflected. On day 2 of our conference, we're actually screening a movie on data labelers and the trauma they go through, and how the data sets of the Asian world is often neglected in the data set that's eventually used for AI to function. So thank you very much for your speech and for answering the 2 questions that were raised. And we're just so glad to have you.
Thank you.
We will be beginning with the first panel discussion. And Jyoti and Chini yes, I think you can hear us. Yes.
Thank you. So we'll be starting our next session about gender discrimination and AI. We will examine the gender dimension of emerging technologies, particularly artificial intelligence, and their implications for women. While technology can offer unprecedented opportunities for inclusion, access, and empowerment, it can also reinforce existing inequalities and biases and extenuate them. In Asia, these challenges are compounded by social, economic, and political disparities, making critical discussions on this topic both timely and necessary. We're going to explore the gender digital divide and threats posed by AI, including algorithmic biases and sexual digital exploitation. We're also going to explore how AI and digital systems reproduce discrimination and stereotyping, the impact of male-dominated tech spaces on women's safety and rights, and we also bring a case study from Korea related to the nth rooms and the deepfake crisis. So first, we're going to introduce our speakers. First, Dr. Jamie Stewart. She's a senior researcher and team lead at United Nations University Institute in Macau. Jamie Stewart is an applied cultural and developmental psychologist who specializes in digital health and well-being. With a focus on computer-human interaction, Jamie's recent research projects have examined a broad range of issues related to social justice, peace, and development, such as gendered influences on cybersecurity and AI, cyberbullying, social media literacies, digital competencies, parenting and technology, online disinhibition, and the impact of emerging technologies on mental health. Her work aims to support the creation of safe, secure, and empowering online spaces for everyone.
The second speaker of the session is Jyoti Vadera. She's a leading voice in digital trust and safety online well-being in India. As head of online safety and well-being at the Center of the Social Research, she leads national initiatives focused on digital citizenship, gender-responsible safety, and emerging online harms. She also serves the founding secretariat of the Alliance for Cyber Trust and Safety, and it's part of the core organizing team for TASI, the first Trust and Safety Festival in India, shaping India's role in global safety dialogues. She is a member of the Meta Global Women Safety Experts Advice Board and works extensively on AI, gender-biased violence, and child safety. The third speaker, Sarah Tae, is an international cooperation lead at Takti Neil, the South Korean NGO advertising for the rights of children and adolescents, and the leading NGO in sex education. Takti Neil is a member of the ECPAT network, a global alliance of 143 organizations in over 100 countries working to end the sexual exploitation and trafficking of children. Sarah holds an MA in human rights from UCL and previously worked in Lao PDR at the UN and international NGOs, focusing on the prevention and response to gender-biased violence. She now works on a policy advocacy and cross-border initiative to address child sexual exploitation, including in digital environments, bringing the perspective that bridges international development and frontline civil society practice. Now, we were delighted to invite our first speaker, Dr. Stuart from Macau. Dr. Stuart, please.
Thank you so much for the introduction and for the invitation. Let me share my screen so that we can start. Just taking a moment. Okay. Okay. Thank you, everybody. So as was mentioned already, I'm Dr. Jamie Stewart. I'm actually now the current head of research at UNU Macau, which is a UN agency that is focused on research and education, and it's one of the only UN agencies. That's the only UN agency that can offer doctoral and master's degrees. So we're in quite a unique position in terms of the research and action that we engage in. So I'll be talking to you today about some of this will include the research that I've been engaging in. I work very closely with UN Women and ITU, which are both UN agencies in the Asia Pacific region, particularly around gender bias in AI and cybersecurity. I'm going to try very hard to stick to my 20 minutes today, and I will have to say that unfortunately I cannot stay for the Q&A session, but I'm very happy for anybody to get in touch with me after the presentation. So it was very nice to see the previous keynote speaker discussing human rights and human rights as a framework for AI. But and I also agree with that very much, and that's how I'll come to the end of my presentation. But actually, I'm going to start with ethics, and particularly with AI ethics. So for those who are wondering what it means, it is about the moral principles and values that should guide the development and use of AI systems. And why do we need AI ethics? Do we need AI ethics? It's a question. Well, it's a critical part of our conversation right now, particularly in the UN, because of the enormous potential of AI for both the positive and the negative. And this concepts around the importance of ethical use, but also ethical development and the ethical implications of AI is because we are increasingly trusting those systems with high stakes decisions. And these decisions are having impacts on our lives in ways that could have unintended consequences. And actually, we are seeing those unintended consequences right now, particularly in the form of exclusion and gender issues. That AI is learning from data which encodes, it is not that it can encode, it does encode human biases and prejudices, and it is reflecting those biases and prejudices back at us and often reinforcing those. Unethical applications of AI could worsen or automate injustice, and those people who experience those injustices are the most marginalized and vulnerable people in our societies. And the importance of all of this is that we need what we call humans in the loop, or also that is human control, but accountability for this, not just amongst individuals, but also amongst individuals and nations, industry and nation states. So we've got to start with this. And many countries, it has been discussed that there is an AI innovation race, but there's also an AI ethics race that is happening in parallel. And we have seen already in 2021 UNESCO's recommendation for the ethics of AI and the values that were embedded in that recommendation. Again, reiterating what the keynote speaker was saying, are actually human rights and human dignity. So we already know, and this was before ChatGPT and all the other generative AI tools came out to make such huge changes as they're making in our society. It was already recommended that these tools need to be on the basis of human rights, and that they should be assisting us in living in peaceful, just, and interconnected societies, ensuring diversity and inclusiveness, but also that they should be based on environmental and ecosystem flourishing. So we have this I guess we can call it a soft governance mechanism that is also embedded within that mechanism is gender. So gender is one of 11 critical policy areas from the UNESCO recommendations, and what is said in that space is that we should use the potential of AI to maximize gender equality and reduce the likelihood of it exacerbating gender-based issues. But what we actually find, what we have found for a long time, is that AI tools and systems tend to have discrete negative impacts for women and girls. And those negative impacts fall into some really critical areas that have emerged from the research that we've been doing in the Women, Peace and Security agenda. So from the report that we wrote on this, we identified these as 4 critical areas. Discrimination, which is providing different outputs for women than for men, simply based on their gender, and I'll show you what some of those have looked like and still do look like. stereotyping, and that is reinforcing, perpetuating, exacerbating shallow, biased imagery of women, particularly imagery that is sexualized. Exclusion, and what exclusion means here is both that women are not included within training data sets as much as men are, but also that women are excluded from decision-making processes. And also from the development of AI tools and technologies. Women are much less likely to be in fields and leading technology companies where they can be empowered to engage in these decisions. And insecurity, which is a critical issue that I'm going to be talking about at the end of the presentation today, which is that it threatens women's psychological and physical safety. So ethics here and the recommendations of the UNESCO and UN's recommendations around the ethics of AI really prioritize a human rights perspective, and that is we're interested in the importance of the tools and the technologies to uphold rights and not diminish rights. But actually what we're seeing very often is that they do have that diminishing quality. So to go back to some of the key issues for women within the space of AI, I'm sure that many of you have heard about the concept of algorithmic inequality. This is that algorithms are inherently biased, and these systematic errors that affect the algorithm, and that what they mean is that you get some outcomes are favored over others. What does this look like? It looks like that data is skewed. And even if you think about the biggest large language models, open AI models that scraped data from the entire internet, that in and of itself is a skewed representation of humanity, because the data on the internet is predominantly in English, which was already briefly discussed. That data contained a lot of biased information, a lot of imagery that represents some groups in ways that are stereotypical, but also really incomplete data. So this is how we talk. This is why we talk about underrepresented language, underrepresented peoples are not and were not included in the original training data sets of the generative AI tools that we currently use. So not only do the models inadequately and inaccurately represent groups, particularly those groups who are historically marginalized, there is a lack of input and validation of these models. And oftentimes we consider them to be a black box. So because they are predictive engines, such that what we get, the output of what we get from a model becomes normalized. And that is really, really problematic. So what you can see from the figure up the top of the screen here is a very simplified representation. We have biased information, that is, the world creates that information, as what was said before. It is not the machine that is biased, it is the information and the people that are biased. It's society that is biased. And we feed that data that we create into a model. The model learns and then produces an action, which then feeds back into the world. So when you engage in a generative AI tool or with a generative AI tool, and it gives you some output that can reinforce discrimination, prejudice, and perpetuates stereotypes and exclusion. So this is particularly important because the information that is being generated by AI systems is also now the new data which is being used to feed into models. So once we get to the end of the data, the original data that we have, we start feeding in AI generated information which itself is biased. And I think you can see that this has a really negative feedback loop. A recent study found of 133 AI systems found that 44% showed gender bias within their outcomes and their training data, and 25% had both gender and racial bias. This is huge. I want to say that there have been guardrails put in place, but I don't necessarily think all those guardrails are particularly effective. So in terms of gender bias in AI, what we can, the way that we see this coming out is that text generation tools portray women as linked to roles such as family, home, and children, much more than men, and linked to traditional non-technical gender representations. So you can prompt an AI with very little difficulty to produce bias. And as I said, there are some guardrails around this at the moment, but very, very easy to get around. We also find that image generation tools portray women as sexualized and partially nude, and this is one thing that of which there has been some work done by model developers on, but it also produces images of women who are younger, who are happier, and who are in lower status positions. So the representations of women as being caring, happy, and sexualized. So as you can see in the box to the side, there was a piece of research that found when asked for visual representations of technical roles, there was very few in which women were easily generated, and in some in which women could not be generated on the basis of a prompt, which is very disturbing. And there are also algorithmic issues, not just bias in the data, but issues with the algorithm, in that women are targeted differently by algorithms in terms of advertising. They tend to be, there was a wonderful study that showed that women were not targeted by hiring-based advertisements for senior executive roles, but men were. And so they never even saw the roles in which to apply for. Also, we know that hiring decisions, which are AI-based, that use gendered markers rate women as substantially lower in terms of employability than men. Misclassification in facial recognition systems is one that's in which women's faces and gendered faces were much less likely to be able to be recognized effectively and accurately. And that's a big part of that is the reason that women's faces, like normal women's faces, are not well represented in data. And text-to-speech and other systems are less accurate for women. And again, one of the critical reasons is, first off, because of less training data, but also less women in the room when decisions are being made about how those algorithms function. So you can see already this is quite a major issue. There was a very nice, quite difficult and confronting communication program that was done by UN Women some years ago, in which this was tested with a simple Google search. So this was again before the generative AI boom, and you don't get the same thing happening now. But what they did to test was they put in a bunch of prompts into Google. In the very first prompt here, you can see that the question was, women need to be put in there, and the autofill. The first autofill recommendation was women need to be put in their place. And so when you start off with a prompt, women shouldn't, the autofill looks like women shouldn't have rights, women shouldn't vote, women shouldn't work. So the other one that they did was women cannot, and the autofill came up as women cannot drive, women cannot be trusted, women cannot speak in church. So this here is a really good representation of some of the gender biases in terms of the autofill algorithm in Google that had come up. Sorry, I'm not sure what happened there with the as that fed forward. So this is just one example. Other examples that we have that gender neutral pronouns languages in which there is no there is no specific gendered term for an element, when they were put into translation systems, become gendered. And so that is to say, a Hungarian, which does not have a gender pronoun in terms of its translation, when you put in the words "they are a nurse," that is then translated into English as "she's a nurse." You put in "they are a scientist," it is translated into "he is a scientist." So you can see that not only are this bias algorithms in terms of autofill and generation, but also bias in terms of translation. And this one at the bottom, where it's the translation, you can see and really understand the stereotypical representations. She is beautiful, he is clever, he reads, She washes the dishes, he builds, she sews, and so on and so forth. And when you look at the correct translation of across roles, what you see is that there are full correct translations of roles like nurse for women, but no correct translations for things like roles like doctor, few for soldier, president, and so on. The other critical thing to note here is that we know that AI is critically related to technology-facilitated gender-based violence. And this is a definition of that from CSW 67. So AI isn't the only mechanism through which TFGBV happens. It is one of the mechanisms. So it can happen in many different ways, and it tends to amplify. So this is I wouldn't say a new and emerging type of violence. This is a violence that's being very widely experienced by women since the increasing pervasive use of digital technologies. Research is finding that a huge majority of women experience online harm, that of those who experience online harm, a recent piece of research found that 15% reported that being targeted impacted on their desire to live. And 60% of women were targeted by men. This differs on the amount of experience of gender-based violence differs on the basis of which country that you live in. Why is this particularly important from an AI perspective? Research in by UNESCO has found that AI has widespread impacts on online violence against women in particular. And this is through some key mechanisms: the spread of hateful, misogynistic, and discriminatory content, of which there are many more vectors than there ever have been, organized and coordinated online attacks and harassment, and technologies of surveillance. And in the report, this report is called Your Opinion Doesn't Matter Anyway, they found that generative AI in particular was a critical vector here, in that it produced more convincing fake media, an increased volume of fake media, new unintended harms, synthetic histories, and compositional deepfake, especially those that are sexualized and interactive deepfakes. So I want to briefly discuss what deepfakes are now, because I know that we'll have another panel member who will be discussing this, and it's critically important because I want to move on to some research that was done in the Asian region. So deepfakes, which are a critical AI-generated vector for violence, are growing at an exponential rate. And they're not just used for sexual gratification, even though we often think that they are. They're used for domination. So we see in our work with civil society and human rights defenders that they deliberately targeted by deepfakes to humiliate, to engage in abusive non-consensual behavior, but really critically in order to remove women from civic space. Misogyny isn't built in to deepfakes, because we also know that deepfake technology, even though the term deepfake itself came from pornography, the technology that is used for computer-generated imagery is used all the time in entertainment. So it can be used in other ways. It just tends to be used for this type of purpose. And the impacts of this are devastating, and they're very difficult to regulate. So I won't be going into this in detail because I know that I don't have a whole lot of time. And what we find across Asia Pacific region is that deepfakes are disproportionately used to target women leaders and women politicians, or what we consider to be women in the public eye, and it is a growing issue. With in the South Asia region, where we just recently completed some research, we found that the cyber threats, especially AI-driven cyber threats against women in the public eye, really fall into two critical factors. And the first one is what we call the broadsword. And the broadsword is targeting of women through things like AI bots, through troll farms, and through online misogyny. So making women in general feel like they don't belong in online spaces. But they were also targeted, and women are also targeted in personalized ways. There's destructive, personalized attacks, which are often sexualized, as I said, where AI tools and technologies like deepfakes are used. We found in our research that a large number of women had experienced issues like deepfakes, false information being spread about them. You can see here that the highest percentage was 55% of people, the women civil society and women human rights defenders, had said that they had received unwanted intimate advances, and 18% had been subject to deep fake images, which may seem less in comparison to receiving explicit imagery, but it is still a huge amount of women that are experiencing a really targeted and devastating issue. I'm going to skip by a couple of my slides, acknowledging the time, but I also wanted to say some positive things about artificial intelligence. AI has really given more opportunities for the empowerment of women and girls than ever before. And what we know from the research across Asia Pacific is that AI-powered tools are actually critical for women and women advocates when they're used sensitively. They're really important in under-resourced contexts to help support civil society and help support women, but they have to be used sensitively. And this is a quote from one of the women in our Pacific research that said that as for AI, while it's a promising tool, I found that it doesn't always provide reliable answers, especially when it comes to traditional knowledge and Indigenous skills. AI tends to focus on Western perspectives and lacks depth and accuracy to reflect local cultural practices. Because of this limitation, I don't trust it, whilst also acknowledging that it really could potentially provide a very important resource. And AI technologies can be used for peace as well. And I want to highlight here that using AI tools for data analysis and forecasting for conflict prevention is very useful for women and community. Technologies for peace like deliberative dialogue AI and chatbots for legal support, as well as using AI tools for cybersecurity and cybercrime protection, like AI tools are being used for deepfake, but deepfake detection tools can also be AI driven, and they often are, for filtering and moderation of these unnotified software and for threat detection. So I just wanted to give a quick example of this. When you think about AI, the bias in AI, when you ask for something like a photo of a firefighter, and by the way, firefighter was one of the roles in which it was very difficult to actually get an image of a woman. So what you generally tend to get are pictures of white men. But there are now ways in which, and this is a specific example, using stable diffusion, where you can introduce this thing called like fairness guidance, and you ask it, you prompt the model with fairness guidance, and then what you get out of that is a much broader, diverse representation of imagery. You get women, you get different colored faces, you get different ethnicities, and so AI can be used to disrupt this process. And I think you can imagine what it means to have a disrupted process where there's diversity represented is way less likely to perpetuate the discrimination and stereotypes. Finally, just to quickly say that AI requires new and expanded governance frameworks. It really, what was said in the keynote presentation, not only soft governance with the ethical frameworks like what I mentioned earlier, but also laws and regulations, or hard governance. And that governance must include accountability mechanisms across stakeholders. So industry is one accountability mechanism, but also we need private and public civil actors to be in that. But there is a huge discrepancy between the accountability. That is, the demand and supply for accountability is really lacking. And I think this is a really important reason why is because AI tools and technologies and many digital tools and technologies are being seen as critical and important things that are required for economic innovation. So like a steamroller, either you are the steamroller or you're part of the road. It's very important that we create gender-sensitive and human-centered AI, and there are specific ways that we can do that by centralizing human factors and at the individual and the collective levels. So this is to end by saying, and I know I'm a couple of minutes over, but that a gender-sensitive, human-centered AI is good for everybody. It's not just good for women. It's more accurate. It produces greater innovation. It makes the world a better place, more peaceful and more safe. And it's socially and economically beneficial. So yes, there are a lot of problems in this at the moment, but there are tools and technologies and work around it. And we need to raise awareness of this, especially the human-centered and human rights-based approaches to developing, delivering, and deploying AI tools and technologies. Thank you very much for your time.
Thank you very much for this insightful presentation, Dr. Stewart. I learned the importance of critically examining how technology is developed and used. And we will also explore the topic of deepfakes in more detail with Sarah, so please stay tuned. So with these important insights in mind, we will now move on to the next speaker, Ms. Jyoti Vadera from India. So please give us a moment, please.
Hi, thank you. Thank you for inviting me to speak, and thank you for sharing the screen. I would just like to begin by saying thank you to my fellow speakers who made my job here much easier. They've already touched upon the topics of AI bias and ethical AI, and I will also talk about these and add the perspective of the Global South to the narrative today. AI is rapidly becoming part of everyday life, and from hiring systems to healthcare diagnostics to financial services. The key question we must ask is who benefits from AI, who builds it, and who might be left behind. Sorry, let me just. Can you please stay on the first slide? Thank you. And because we do not address gender inequity, if we do not address gender inequities right now, AI risks automating existing inequalities at scale. So AI is the most powerful tool for equity in a generation, and if we get it right, we have the opportunity to control the gender inequalities right now. We already see examples where AI is helping women in the Global South. Language translation rules are breaking literacy barriers. AI-powered maternal health diagnostics are reaching rural clinics. Alternative credit scoring models are helping women without formal banking histories access microfinance. So the conversation about gender and AI is not about rejecting technology. It is about ensuring it is designed exclusively so that its benefits are distributed equally. Next slide, please. When women are involved in building technology, the outcomes improve. We see this in several inspiring examples. So organizations like Policy in Uganda are shaping gender-responsive AI policy frameworks. In India, AI for Bharat has built language models while actively recruiting diverse researchers. And projects like Khushi Baby use AI design alongside frontline health workers like ASHA workers to improve maternal health tracking. These examples show that representation in design changes the impact of technology. Next slide, please. Despite these successes, there is a deeper structural challenge. AI systems learn from historical data, but historical data reflects existing social inequalities, including gender bias. So when systems trained on this data are deployed without safeguards, they can replicate and amplify those inequalities. So AI does not care about bias from scratch. It inherits and automates it. Who designs AI? Next slide, please. One major reason bias persists is who is building AI systems. Globally, women hold only 12% of AI research roles. And in South Asia, tech hubs only have 8% of senior tech positions that are held by women. In India, although women make up 43% of STEM enrollments, they represent only 20% of the AI workforce. This shows that participation drops significantly between education and professional leadership. Often people say that the pipeline is broken, but evidence shows that women are entering STEM fields. Next slide, please. The problem is that they leave at key transition points, especially mid career and leadership levels. When women are missing from decision making roles, technologies reflect blind spots in lived experience. So, this is not a talent shortage, it is a structural issue in retention and advancement. Next slide, please. So, another often overlooked dimension is the invisible labor behind AI. Over 200,000 rural women in the global south are involved in data labeling and content moderation. This work can involve exposure to disturbing, traumatic content. Yet it is often treated as gig work or minimal protections. And AI depends heavily on this labor. But the workers rarely benefit from the technological advancement they enable. At the same time, women often have less time for professional development due to unpaid care responsibilities. Next slide, please. So even when AI systems reach users, the benefits are not evenly distributed. Many assistants default to female voices or for subservient roles. And research shows that professions like nurse are associated with women while scientist is associated with men. These design patterns reinforce long-standing gender stereotypes. Talking about the access and the digital gender divide. Yes, next slide, please. Access to AI is also shaped by digital gender divide. In South Asia, women are roughly 30% less than men to use the mobile internet. Without connectivity, people cannot access AI tools or digital services. Access also includes digital literacy, safety from harassment, and also time to participate online. And many women experience exclusion on multiple levels. Bias has real world impacts. So, Amazon's experimental hiring algorithm once downgraded CVs that included indicators associated with women. And scoring systems sometimes penalize women who lack formal credit histories. Healthcare AI systems may perform poorly for South Asia or African women due to underrepresentation in training data. These examples show that algorithm bias can affect jobs, finance, and as well as healthcare. Next slide, please. AI is also changing how online harm occurs. Generative AI makes it easier to create realistic fake images. For survivors, the distinction between real and fake often does not matter. The harm is very real. These tools are being used for sexualized humiliation, coercion, sextortion, and harassment, particularly against women in public life. Safety cannot be an afterthought. Next slide, please. Deepfake abuse is increasing rapidly in South Asia and Southeast Asia. AI-enabled surveillance technologies are sometimes used in context of domestic abuse or political repression. Moderation systems also struggle with regional languages, leaving harassment unaddressed. When platforms cannot protect users, many women withdraw from digital spaces entirely. So at CSR, we work a lot on advocacy for safety online. And our recommendations are three tiers of action. One, firstly, we design transparency about diversity in AI teams and bias audits before deployment. Next slide, please. Yes. And secondly, labor. Recognize data labeling and moderation as formal work with protections. Thirdly, access. Invest in digital infrastructures and close gender connectivity gap. These steps help ensure that AI systems are equitable and more inclusive. The most effective solution comes from co-creation. Community women and civil society define the problems, technologists build the tools, frontline workers test them in real world conditions, and policymakers ensure regulation at scale. When those most affected help design the system, safety becomes part of the architecture, which is what is called in this space as safety by design. So AI has the potential to be one of the most powerful tools for equity in a generation. but that outcome depends on intentional design and inclusion. Uh, and at the Center for Social Research, we work on advocacy, research, and capacity building around gender equality and safety. We engage with technology platforms to address tech-facilitated gender-based violence. Forums like this are incredibly important and that they help us take this conversation beyond our organization and into a wider audience. So I'm happy to, we're always happy and open to collaborate to help strengthen this work. Thank you so much.
Thank you so much for this insightful space. We've been seeing throughout our panel that technology is not neutral and it reinforces existing structural inequalities and how in the global south it increases or makes harder to access certain services that are actually needed for survival or for basic functions, and how women sometimes are excluded from enjoying them in the same way as men. Thank you so much for helping to contribute to this panel. Now, for our third speaker, we would like to introduce Ms. Sarah Tae from South Korea. Sarah, the floor is yours.
Hi, everyone. Let me just share my screen. Can you see my presentation?
Yes.
Yeah?
Yeah.
Okay, great. Okay, hi, my name's Sarah. I work for Takti Nail, which is an NGO advocating for child and adolescent rights in South Korea. We're also part of the ECPAT network, which is an international coalition of 141 civil society organizations across the globe, and we're all dedicated to ending sexual exploitation of children. And today I will be presenting a little bit about how South Korea has shown that gender-based violence perpetrated through AI not only victimizes individuals, but it also changes who can participate in public life. And that even without open intention to discriminate, the outcome ends up being very discriminatory. And so I'll start with a very brief history of digital sex crimes, as they're called in South Korea, for a bit of context. And I'll dive a bit deeper into the Nth Room case and the policy reform that came about after the Nth Room case. I'll move on then to how AI changed things, the reforms that followed, what this revealed about formal versus substantive equality, and end quite briefly with what Takti Nail is doing in this area. So for a brief history, in the early 2000s, high-speed internet became available to everyone in their homes. And during this time, this website that you can see in the top left corner, SoraNet, was established. And it was an online community where people could share sexual exploitation material. And they were predominantly illegally filmed photos or videos called 몰카, which means hidden camera. And nowadays, we're not using the term 몰카 anymore, but that was the type of content that was being uploaded. And at its height, it had more than 1 million users. And then it was shut down in 2016, but there was already a copycat website called AV Snoop, which gained more than 1.2 million users with similar content. Then in 2018, sorry, there's a typo here. 2018, the Web Hard Cartel case was one that kind of shocked everyone because it was it involved a content removal service provider, some company that's trusted with taking down content, but they were using that content to actually redistribute it, re-upload it, and gain some profit from it. And they were called a cartel because they had this whole ecosystem within it. And this was actually the first, or not the first, but one of the times that rights organizations were calling for the prosecution of also people distributing and who were distributing for profit. Then around the same time in 2019, there were starting to be reports of Telegram rooms sharing explicit content, and this would be known later as the Nth Room case. And in 2019, also, the Burning Sun scandal happened. And so I'm sure the people who might be familiar with K-pop might recognize these men in the photo. But this case was a whole shock through Korean society as high-profile celebrities were found to take non-consensual sexual content and share this in messaging apps. In the same year, 2019, a dark web Korean website hosted in Korea trading CSEM, child sexual exploitation material, welcome to video, was discovered. And this site also had around 1.2 million members, and this was widespread. There were 4,000 plus members who were paid members from 38 different countries. And I think amazingly, the perpetrator was only sentenced to 1.5 years. And this also triggered more calls for reforms to happen. And then, of course, the Telegram Nth Room case, which if you Google, you'll be able to find all of the details on there, on that case. But this was it was a big reckoning for Korean society because it was operating at such scale, and the severity of the exploitation was to say the least shocking. And then fast forward to 2024, the deepfake crisis happened, and I'll get into that later. So as you can see, with each case that happened through since the early 2000s, legal reforms have been made to close the gaps, but these were always a step behind. And the technological advances just keep getting faster and faster, making it more difficult for the laws and policies to even preempt. So just for a very quick explanation of what the Nth Room case was, is it involved a whole network of people that you can see on the left, where the main operator would blackmail victims into sharing content. He would distribute that to paid members of the Telegram room, and this cycle would continue. And so what set this case apart was the fact that it didn't just involve one single offender, but it was a whole coercion and subscription model to sexually exploitative material. And yeah, it really forced the country to recognize that digital sexual exploitation is organized and is profitable and it's networked, and it's not just simply a matter of individual deviance. And so that really sparked a huge reform moment in 2020. There was huge public attention to the case, and civil society pushed really hard for demand-side accountability and victim-centered responses. Tactile Nail was really at the forefront with a lot of sister organizations doing public petitions calling for the prosecution of perpetrators, for their identities to be revealed publicly. Lots of public campaigns in front of important institutions, and most importantly, working closely with the lawmakers for the legal reform. And actually, every time the state does act, and this time it also did as well. And so basically it did three things. It expanded liability beyond just the producers to also include possession and viewing of material illegal, and also using this content to intimidate and for compulsion. It also strengthened offenses around the threats and coercion using these sexual images, and stronger platform and remedy expectations, including deletion support and rapid deletion support, I should say. But these reforms were designed for a world where content was real and distribution was comparatively slower and contained. And AI kind of broke that assumption. So the AI created a big shift, I could say. 98% of all deepfake videos online are actually deepfake pornography. And the number of deepfake porn has increased 464% from 2022 to 2023. So you can see how rapidly the AI generated content is being spread online. And actually, you can see from this data set that Korea was actually fertile grounds for a deepfake crisis to happen. Korea was leading in the number of deepfake pornography in the world back in 2023. I don't know for now, for the 2026 data, but back in 2023, this was the status, and we really should have seen coming this deepfake crisis that we call it. So in 2024, that actually happened. And what happened was that Telegram rooms operating in a similar way to the Nth rooms were sharing deepfake pornography, this time not of celebrities or public figures, but people that they had proximity to, like the people in their schools and community. And interestingly, what they got a kick out of was humiliating these people that they had in common. And so these overlap rooms that you can see in the top left were organized by the school name. And in these rooms, members would ask if they knew so-and-so from such and such school in this grade. And by knew, it means if they knew them in real life. And so once someone was identified as a acquaintance, like a common acquaintance, the members would make a separate humiliation room where they would upload photos of the individual, photos that they might have taken, but also photos that they could get from their social media accounts, and also share their personal information. And again, not just of the person, but also the family members. Then one of the people in these humiliation rooms would take the photos, use a deepfake bot, a nudification bot, to make the pornographic images and videos of the individual, which they would then take back to the humiliation room. And that would just be what they were having fun with. Then they would share the links to the humiliation rooms in these link sharing rooms. And that would bring more people into these overlap rooms. And this was so systemic and widespread that a map of schools was made to show which schools had been affected. And if someone saw that their school was on the map, usually a female student or a female teacher, they would also join Telegram to check if they had been victimized. And yeah, this affected all age levels, from elementary schools to universities. And as I said, students would even deepfake teachers, family members. And it was also found later that female military personnel were also targeted in certain dedicated rooms as well. So what set this deepfake crisis in 2024 was that no original sexual image was needed. So a victim didn't even know that they had been victimized. Usually they'd be informed by police or a peer. And so that created a new type of fear where any person with any online presence could be targeted without their knowing until it would be too late. Another characteristic was that it was perpetrated against peers, often in the same classrooms, and schools could realistically not remove the threat without removing half of the classroom. So in practice, victims ended up having to move themselves out of the school. Teachers, as I said before, who had been victimized also had no choice but to continue teaching students that had made deepfake videos and images of them. And the deepfake crisis also outpaced the response systems that were set in place following the Nth Room case. The sheer scale of the Telegram rooms and the deepfake material was just too much for the deletion agencies to be able to respond quickly. And finally, the deepfake crisis also forced society to face the fact that a fake image or a video doesn't minimize damage at all. For me, I thought also that the knowledge that something is fake would be reassuring in itself. But when I saw how easily you could make a pornographic video or image just with a photo, made me completely change my mind. It can still create social stigma and continues to place the burden of proof on the victim. And so Korea did respond, thankfully, after the deepfake crisis. That strengthened, the extending the demand side logic to certain deepfake sexual content. So it also included sexual exploitative deepfakes for it to be illegal to possess, purchase, store, and view this content as well. Before, it was only for illegally filmed content. So it was and it also led to the enactment of the AI Basic Act, which was already in the process of being developed, but it accelerated the enactment. And this Basic Act is the first in the world it aims to address trust and transparency in AI systems by requiring platforms to label the AI-generated material and delete illegal content and ensure cooperation with the law. But as we could see, there are still some limitations in ensuring that people online can be safe. And the courts are still constrained by the existing sentencing guidelines, and more importantly, by individual perceptions of what deepfake content can mean to victims. As I said before, victim support is realistically unable to contain and respond to the distribution of deepfake material. There's weak international cooperation, and a very important thing is the prevention gap. The education and cultural drivers of why this case became so big is yet to be addressed. And so what I wanted to highlight through the the deepfake crisis is the fact that even with reforms, systems can still lead to discriminatory outcomes, can still squeeze women and girls out of participation, even if the intention is not to do that. So this is where the human rights framing helps. Human rights doesn't just ask, is the rule neutral, but rather, do people enjoy rights equally in practice? We had talked to a teacher who said that female teachers are unwilling to appear in graduation albums following the deepfake crisis. Some children will only allow their photos to appear side on. What message does this send to girls? So that's really the distinction. Formal equality is, making equal rules, but on paper. And substantive equality means ensuring the equal ability to participate and enjoy rights. And when the option for women and girls to be safe is to become less visible in these online spaces, that means that equality doesn't happen in practice, but it just exists on paper. So discrimination is occurring by effect, not by intent. And that's really the difficult thing, that that policy is not itself enough to ensure the safety of women and girls online. What we at Taktin are doing is trying to bring that to light. We continue to document patterns and publish issue reports, and we're working with educators to develop a digital citizenship education curriculum. We're campaigning for the integration of comprehensive sexuality education in schools. And we're also hoping to, raise awareness on these issues and translate this evidence into policy asks, briefing decision makers and pushing for prevention and remedy systems that can reduce the burden on victims. And I think the deepfake crisis in Korea reminded us that the visibility of women and girls alone is actually risky. And the only rational response to danger was to withdraw. And if the only option for women and girls to be safe is to be less visible, then this really isn't just a tech problem. It's also a human rights failure. And that's not just, the question is it by design, or is it just very badly designed? So I just want to close. I know I'm running out of time. That the harm isn't just the image or the video, it's also the silence that follows. And AI actors really need to go further to ensure not only that it's safe to use, but also participation in the public arena online can be safe as well. So thank you for listening, and I look forward to your questions.
Thank you very much, Sarah, for eye-opening presentation. Why I was impressed by the strong civic response to and legal reform after Emperor case. But I also realized the urgent need to address the expanding and structures, increasingly sophisticated deepfake crisis from human rights perspectives. So I hope we can ask a little bit deeper in the following Q&A session. So for now, I would like to thank all three speakers for their thought-provoking presentation. Thank you very much.
So we're going to review our chat to see if there are any questions online. Since there is not, we have some questions from the room. And the first one is related to what you mentioned about the stronger penalties for platforms. So we were wondering, how do these penalties work with international or services such as Telegram, and if there has been any cooperation from these platforms with the government? Can you hear us?
I can hear you.
So that was the first question. How has it been the cooperation of these platforms with the South Korean government, and after the stronger penalties, and if these penalties, for example, in platforms like Telegram have been applied, or how do this process work?
That's one of the difficulties that we're facing in Korea, that the investigative agencies, law enforcement agencies, are not able to have as much access as they would have to a South Korean based platform. So, for example, working with Telegram has been very difficult to find not only the operators of these rooms, but also the people who were participating. And as you would have seen, just a fraction of people who were involved in even the nth room crisis were even detained or prosecuted. And so, yeah, that's still one of the difficult areas that we're facing in terms of ensuring that the policies are followed through. At the same time, there are always these ways to get around what policies exist. So, for example, KakaoTalk, I'm not sure if you've heard of it, is kind of like the Korean WhatsApp, but it's very like we have everything linked to our KakaoTalk. And there is a function called open chatting. So a lot of young people are able to go into random chat rooms and chat with strangers. This has led to a lot of cases of victimization. But KakaoTalk has been saying that for them, they are, because they require user authentication and their identification to be verified when they're signing up, they are able to catch perpetrators quicker. But there's still a gap because people are still able to access minors on these platforms. And so what we at TechTeen are trying to campaign for and advocating for is that there's a parental block by default. So KakaoTalk should make the applications of minors not able to use this open chatting function as a default, and that it would require, we are calling for it to require the parental permission to be able to use these platforms. So this seems like a really, how do I say, a very logical, easy way to stop minors from being able to, or strangers from being able to access minors. But it's still very slow, very hard to convince platforms that this is a priority and this needs to be changed. It sounds like something that should happen really quickly, but it involves a lot of negotiations, a lot of persuasion on the part of civil society organizations to the platforms. So yes, there's a lot of progress and changes being made, but on the ground, in reality, there are still some hurdles that allow for perpetration to continue very easily. Yeah.
Thank you so much. We got our one question in the chat, and it says, you mentioned it is not a tech problem, but do you think the lack of female leadership in companies across the world is exacerbating this problem?
I really can't say if that is a causation. Yeah, I'm gonna say that first. But there is really a lack of emphasis on how we look at women's safety. So as I said, it's not just, having a door that says, women cannot come in, that means discrimination. It's also these silent ways that, as women, we kind of know when we're getting pushed out. And when platforms don't allow for women to be safe, and we feel like the only safe option is to get off those platforms, then in that way it is discrimination. So I think, I mean, yeah, I can't say for sure that it is a leadership issue, but there is definitely a lack of awareness from this angle of looking at discrimination in this implicit way. Yeah, I hope that answers.
Thank you so much. We have a couple more questions.
Okay. So it seems that regulation and education for protect children from harmful content and to prevent from like becoming victims or perpetrators are lagging behind technological development. Also, the situation seems to be getting worse, especially with like expansion of movement like manosphere. So could you briefly tell us about the work being done for children in this area?
Yeah, it's we at Tech Team, we feel that it's very important to start education on not only, you know, safety and how to stay safe on platforms, but also what digital citizenship means. And we very much emphasize in our upcoming new curriculum related to digital citizenship that gender equality education should be a priority when we're talking about digital citizenship, because of, you know, how power relations, how social norms get so amplified on online platforms. And this, yeah, it needs to start young. But the environment that we are in Korea is still seeing this topic, such as comprehensive sexuality education, as something that's contentious. There's still a lack of consensus that this is necessary, why it's necessary. And so the rights organizations, we have to still do a lot of fighting, even though this seems quite obvious to a lot of us. So that's really a lot of our work in trying to advocate for younger education for younger students on these types of issues, and expanding the focus not just on, you know, keeping ourselves safe, but also what it means to be a citizen, a digital citizen, as we call it. Yeah.
Thank you so much. We would like to ask you too, if with so many victims from the F rooms or the deep fakes, where do the resources for the reparations come? So for the reparations, does it come from the perpetrators or from the South Korean government? And apart from the deletion strategies, what other means are there to repair victims?
Yep. So in Korea, we've had a very long history of fighting for victim support. So the system for, you know, support to victims of sexual violence is very strong. And so the support being provided to victims of digital sex crimes, of course, is connected to the sexual violence support. And so on top of, you know, the normal psychological support, legal support, medical support that's required, there's also the deletion support that's provided. And this is usually covered through the national budget under the Ministry of Gender Equality. Yeah, so as Tuckteen, at Tuckteen, we also have a sexual violence counseling center in-house. So we receive a lot of victims who, you know, for counseling support, for advice, and this is all covered by the government. The government funds civil society organizations who are certified to be providing the sexual violence services. So it's all kind of very well structured support system. On top of that, we also do education of perpetrators. Usually they're short-term kind of educational training that people need to undergo once they've received a court order. And sorry, what was the second part of your question? I wanted to answer that.
Yes, if what other mechanisms are there to repair victims apart from the deletion services? But I think you already covered.
Yes, so that's yeah, exactly. We try to provide very comprehensive victim support services in Korea, and I would say it's very well funded and very well structured. The only problem is that there is a very high concentration in like big cities. And so people who are in the smaller cities have more difficulty in accessing these services. But otherwise, they do get very good support, I can say so, from our counselors in our counseling center. Yeah.
Thank you so much. We have one question in the room.
Hi, Sarah. Thank you very much for your very engaging case that you presented. I've got a curiosity. I'm wondering, has civil society in South Korea explored the idea of getting BTS, Blackpink, Twice, New Jeans, your sensational K-pop stars to assist in this advocacy attempts? And if, imagine tomorrow, they approach your organization willing to help, what would you like them to help you with? How would you like them to help you? Thank you.
That's a very interesting question. And I don't want to assume for any of these, K-pop stars that are doing excellent jobs around the world. But I feel like one of the barriers is how contentious and sensitive this topic is. And in the past, Taktin also had worked with celebrities to bring attention to this issue. And usually the fact that we're a child rights organization is very helpful to getting these high profile people on board with our messages. But I feel like it's from observation, we do have less engagement with, these influential K-pop stars, celebrities, public figures. And I also wonder why that's not explored as much. I'm just thinking maybe it is because of the sensitivity. This is something I'm going to ask back at my organization, and maybe we'll be able to, find a way. But as you might be able to see from the Security Hero report from 2023, most of the deepfake pornography involved Korean singers. I think it was like 90 something percent. And I do wonder why they weren't involved and engaged in the messaging against, AI generated sexual content. So yeah, this is a really interesting question for me to also explore with my organization, but I think it could be to do with the nature of these crimes. Yeah. Sorry, I don't think I answered your question, but maybe I'll be able to get back to you talking with my organization and through the organizers.
Thank you so much. We have another question related to the humiliating rooms.
Mm-hmm.
So we know the big majority of victims were women, but for example, if the nature of the content was also gendered, apart from the profile of the victims being gendered, So if it was, how was it different? So how was the experience different from men for women?
There were also a lot of, there were also male students being targeted, but the statistics show that 97% of the victims were female students. So, yes, of course, there's a gendered aspect to the fact of their sex being female, but it just shows how willing male students, men, are to humiliate women. And the reason for the humiliation would a lot of times be for humiliating women who are doing better, let's say, than them. So there's a lot of tension in Korea, that, the fact that girls are doing better in schools, girls are getting more education, and this really impacts how men and boys feel. And so this deepfake, deepfake crisis really showed how the men needed to express masculinity in this way, superiority in this new way. There were usually the boys and men who were victimized also were perpetrators themselves. They became perpetrators themselves. And so this creates a whole cycle of, victim becoming perpetrator. But that wasn't really seen as much with the female victim, dynamics. So yeah, I'm not really sure if this answers your question, but you do see online, on online platforms, this amplification of what exists in the real world. Let's say the unhappiness of men and boys, the fact that they are attributing a lot of their unhappiness through comparison with their female peers. And so, it was not just, of course, the victims being gendered, but also the dynamics of the tensions between the genders being manifested in these online spaces as well.
Thank you so much. It's another question we got from you is mostly like, what are the next steps for Tactin and for you as a human rights advocate? So, what are the next steps to expect in relation to the crisis or your work as a human rights advocate?
Mm-hmm. At Tactin, we're continuing to campaign, bring awareness, not just to, the gender discrimination through AI, but also through other phenomenon. For example, we had recently done a monitoring of online spaces, which were basically advertising how to engage in child sexual exploitation in other countries. And this whole ecosystem of not just websites and Telegram, like messaging apps, but also YouTube, different blogs, and these all feeding into each other. And so we're trying to bring more attention. Things get, pushed away. But all we can do really is to keep showing that we haven't forgotten about these cases, that we are interested in seeing women and children being protected, and continuing to work very closely with the Ministry of Gender Equality to have these laws and policies passed. I think there are a lot of bills in the process of being enacted or being passed at all. But this is such a slow process that it just requires us to continue being involved and being engaged with the lawmakers, other civil society organizations, and just really being unrelentless and being very annoying with our messaging. And just really, this is very cliche, but not giving up and not forgetting about it. And yeah, there's always a new issue that comes up, and we try to deal with that issue as well. We bring it into, all of the other issues, showing that they're all connected. But yeah, it's a long process and it's hard, but we have to keep bringing it to the fore. Otherwise, it just gets, goes into the background and lost. So that's really the focus of our work, bringing things to the fore, always, and yeah, being unrelentless about it.
Oh, that's amazing. Thank you so much.
Thank you so much. The final question from us is about the career. So I would like to hear from you who have built your careers in the field of human rights, about any advice or key principles you have followed in developing your careers in this area.
Okay, thanks for the question. I was also a human rights student, MA human rights student at UCL. So being in a room virtually, I guess, though, with students, it makes me very happy to see. And what advice I would give you, now I'm at the stage where I'm giving advice, is it's really funny how things work out. I had no idea that I would be working in an NGO for child and adolescent rights when I was a student myself. I was also previously working for the UN in Laos, also on GBV and women's rights. And at the time of being a student, I had no idea. But yeah, I'm now in this position, and yeah, you just have to keep going. You always have to have your principles. You do what you believe in, and you don't compromise on them. And this sounds all really cheesy. And if someone was telling me this when I was a student, I'd be like, yeah, it's easy for you to say you've done all these things. But literally, I've been where you are sitting as well. And it's really cool to be able to do the things that you're passionate about. And it really, it works out. It works out and it's pretty cool. And you just have to keep going and really stick with your principles. Do the, try to deliver the best you can in the way that you think is correct. And yeah, this is really cheesy and cliche advice, but it's kind of true. So I will have to say it.
Thank you very much. As a student studying human rights, I learned a great deal from you. Thank you very much.
You're welcome. Thank you.
Yes, so this is the end of the first session, Gender Discrimination and AI. So thank you, Sarah, for joining us today. Thank you.
Thanks for inviting me. Have a good day.
So we will now take a short break, 30 minutes break until 11:55 UK time. So yeah. Next session, the Developing the Digital Divide, will begin at 11:45. We hope to see you again in the next session. Thank you.
Hi, good morning. Just wanted to check if the audio is okay. Can you hear us on your end?
Good evening. Am I audible?
Yes, we can hear you. So let me just give the audience brief
No
introduction.
issue, no issue, no issue.
Right. So thanks for coming back. So we are going to resume our session for today. So for this session, we'll be focusing on the topic of the expanding digital divide. So the session aims to move beyond mere infrastructure gaps to examine the concept of the connectivity paradox. We'll explore how institutional lags prevent marginalized groups from realizing their right to development, challenging the assumption that access automatically equals inclusion. This talk will provide invaluable insight into the legal architecture of the digital divide, especially insight into how intellectual property regimes and data ownership laws interact with the right to development and how it interact with the digital poverty trap. And also the talk focuses on the global South context and how Asian nations better assert data sovereignty and ensure that global cyber regulations reflect the realities of the global South. For this session, we have an honor to welcome Professor Vivekanandan. So Professor Vivekanandan serves as the Vice Chancellor of the Digital National Law University, Raipur, and has been a legal educationalist for over 3 decades. He has earlier served as the founder dean of the School of Law at the Bennett University between 2017 and 19, and served as the dean of the Rajiv Gandhi School of IP Law at the Indian Institute of Technology, Kharagpur, in 2009 to 10. He earlier served as the MHRD IP Chair Professor with the Government of India and was involved in policy negotiations at WIPO Geneva between 2013 to 15. He also was an elected member of the Asia Pacific region at the large advisory committee of Internet Corporation for assigned names and numbers between 2008 to 10, and as a non-com member in 2010 to 11. Professor Vivekanandan teaches IP laws, internet laws, and corporate laws, and has been an adjunct visiting professor with the Business School of the State University of New York, Buffalo since 2007. He was a research scholar at the Maastricht University, Netherlands, and Institute of Intellectual Property at Tokyo in 2010 and 2015. He was bestowed with the Innovation in Legal Teaching by Society of Indian Law Firms and MILAT in 2017, and is also serving as a jury member of the CII Innovation Awards Committee since 2015. He served as the president of the Consortium of National Law Universities in the year 2024 to 2025. So Professor Vivekanandan, welcome, and the floor is yours.
Thank you, Adil, for the kind introduction. So I will begin my talk or presentation. Am I right?
Yes, please.
Thank you. So let me first place that thank your center at Essex for inviting me to share my thoughts on this important topic, which is assuming greater significance with the last couple of years with the advent of artificial intelligence and its spread in every walk of life. So let me begin with a small paradox that captures the dilemma of our age, which will be easier for us as an introduction to what we mean by digital divide or the connection paradox. A farmer in a remote village in India today may hold in his hand a smartphone that has more computing power than the machines that sent humans to the moon in 1969. Through that device, he can access global markets, watch lectures from world's leading universities, maybe like Essex, and communicate across continents instantly. And yet, despite this unprecedented connectivity, his economic reality remains unchanged. The knowledge he generates through his data his searches, his digital interactions may travel silently across the world, processed by algorithms, stored in distant servers, and converted at times into patents, profits, or technological advantage elsewhere. In other words, he participates in the digital world, but he does not necessarily own the value it creates or even oblivious to the whole thing, what is happening. So today one can tell that everybody have an access to smartphone, but what do you do with the smartphone, how participative you are, and what kind of access you have, and what happens around you is the paradox. I call this the paradox of our time, of technological juggernaut moving ahead, but human beings, as part of, in a way, what a movie like Modern Times, which portrays that you are a cog in the wheel in a different way. So we live in the most connected era in human history, yet the benefits of that connectivity remains unevenly distributed. And this topic, what has been done by the Center for Human Rights, it's basically, trying to analyze this. This is also can be described in another term which you given for me to deal with, called the connectivity paradox, a world where technology promises universal inclusion, but simultaneously produces new forms of exclusion. To understand this paradox, in my opinion, we should step back and examine the deeper historical pattern, how technology, law, and economic power have interacted across human history. Because every major technological transformation, from agriculture to industrialization to artificial intelligence, has not only created progress, but also has produced new divides. Today, we stand at the threshold of yet another divide, what I call the divide of those who own knowledge and those who merely consume it and being directed by such owning of knowledge. We live in what is often described as the most connected age, which I told you, but digital technologies have collapsed distances, it has accelerated communication, and created unprecedented networks of information exchange. But as I pointed out, this remarkable connectivity hides a paradox. Even as societies become more digitally connected, inequalities in knowledge, opportunity, and technological power, on the other hand, is definitely widening. The digital divide today is therefore not simply about who has the internet access. It is about a wider gamut of who controls knowledge, who owns innovation, and who shapes what we call the architecture of digital governance. To understand this phenomena properly, as I pointed out, one needs to little step back and examine the long economic history of a human civilization. Because each technological transformation has historically produced new forms of inequality. If I condense when I call the human history of thousands of years, let us, at least for convenience of our discussion and discourse, make it at least as three phases. Phase one, which we all agree, is the hunting-gathering economy. For much of human history, societies existed in small hunting and gathering communities in different parts of the world. Today, where we are marking as sovereign nation states, it was not marked as sovereign nation states. Let us call the vast spread of the planet Earth, they were all in groups. One should, with differences in analysis, all will agree the societies at that point of time were largely localized. It was participatory because of its very small group nature, and it was also resource sharing. So one can assume that knowledge in these societies were collective rather than proprietary. There were technological tools which existed in those particular period, such as hunting instruments or some precursors to agricultural economy, but they were not owned as we see in the modern legal sense. So access to resources were governed largely by customary norms rather than formal legal systems. While these societies were not free from hierarchy, they did not generate the large structural inequalities that later economic transformation would create when it rolled into the history. So this is one of the phases for us to understand economy, people control their own lives, how equality or inequality was playing out. If we move to the second phase, a distinct phase is the agricultural economy. The first major structural divide in human society actually emerged with agricultural revolution. Agriculture required stability, territoriality, and resource control. Land became the central economic asset. This produced a profound shift, what you call as the emergence of private ownership of the land. Once land ownership emerged, societies began to divide, at least between those who owned the land and those who worked on the land owned by the others. So this emerged, one can call the first enduring social divide, the divide between the landed and the landless. This transformation in turn generated new legal institutions, including property law, tenancy systems, land revenue structures, and agrarian hierarchies. It is in this phase that the many early struggles of economic justice and human rights began to take shape, including peasant movements and land reform campaigns in many parts of the planet Earth. So this you can call it as the second, what I call structural phase. For it is basically for the convenience of our discourse that we are trying to have some models in front of us. Then you can call it phase 3, the Industrial Revolution. The Industrial Revolution marked the second major transformation in the structure of inequality. Technology and capital replaced land as the central resource of economic power. Factories emerged as the dominant economic institutions, and societies reorganized around such industrial production. What does this augur? A new social divide emerged, what popularly also called as the divide between the haves and the have-nots. Industrialists and investors accumulated the power of wealth through the ownership of capital and technology, while millions entered the factories as wage laborers. The factory assembly line became a symbol of industrial modernity. Workers earned wages, may be sufficient for subsistence, maybe not sufficient for such subsistence, but ownership of the means of production remains concentrated with the owners, or what you call as those who own the factories. So this phase also witnessed the automation of the individual, where traditional communities, what we found in its high point in hunting gathering, which took a bit of a transformation in agricultural economy, got substantially weakened as individuals became the economic units within the industrial systems. Charlie Chaplin's, Modern Times is a telling movie about what we are really talking about. Industrial revolution and where the individual stands. So the legal systems also responded, or it got shaped by such transformation. What we had is the development of labor law, trade union rights, and social welfare protections. So these three can be considered in the last many centuries as three distinct phases of, I would call it even, political, economic, and social factors, which were shaping what the history is all about. Then comes, in the last few decades, probably 3 to 4 decades, with the advent of basically internet, then comes what is the term popularly bandied about called as the knowledge economy. The late 20th and early 21st centuries have witnessed yet another economic transformation, what you call the rise of knowledge economy. This economy is driven by scientific research, technological innovation, a venture capital ecosystem, and also two important players. One is higher education institutions and intellectual property regimes. So higher educational institutions became another, what I call, very crucial institutions which are almost replacing learning centers of what religion used to be in the medieval times or before. And this becomes what we call quote unquote secular institutions, but at the same time, they are part of another elite bandwidth along with scientific research. And then law also responded or catered to stabilizing what you call capitalism in terms of intellectual property regimes, which no discourse of connectivity, no discourse of such paradox or what human rights cannot be discussed without touching upon the intellectual property system at the background. So knowledge itself now becomes the primary factor of production, which does not obliterate the agriculture or industrial units and production, but the engine, I call it, of this train is knowledge economy, and others are bogies. So people who are the helm of the engine are the one who drive the train to the destination they desire, and the bogies have no big role but to follow the engine. So the knowledge economy, you can call it, is last few decades, what you call how it transformed business, how it transformed stock market, indexes, anything what you call. So in earlier periods, resources such as land or machinery generated the primary wealth. Today, wealth is increasingly emerging from ideas, algorithms, and data. So the knowledge in the modern economy is not simply shared. It is also increasingly owned, patented, encircled, and monetized. This produces a new structural divide, which we can call from haves and have-nots to a new phrase called as a divide between knows and know-nots. Knows means who know what this technology is up to and what the future is, and know-nots are those who simply may benefit to some extent, but at the same time do not know who leads, for what it is being led, and what is their participatory role. So I would say those who are control, or you can call it helm of affairs of universities, research infrastructure, technology companies, and intellectual property systems, they process enormous economic, advantage and direction. So the many societies around that remain as consumers of technology rather than owners of any kind of innovation, or people who can direct the innovation to a particular direction. So this, in my opinion, is very important for us to understand, because the current issues of anything relating to human rights interface with technology or internet, you call AI, did not suddenly jump from the sky. It is part of a pattern of certain economic, processes which changed over a period of time. But at the same time, one thing was distinct was from participatory to highly controlled, highly, what I call a techno scientific regime complex with attendant political, alignment is what today we witness. At least in this context, the topic which you people ask me to share my thoughts revolves around. So if I look at more specifically from this historical analysis to the jurisprudence of human rights, which is the core concentration of your center, I would say to start with, very interesting observation by Christian Los Lange, who said, technology is a useful servant, but a dangerous master. And that's what we are staring at in terms of AI, where voluminous things are being produced. Proverbially speaking, people in today's technology analysis or the proverbial, elephant and the, five blind people who are trying to figure out what this species in the hall with their eyes, tied up, they're trying to do. That is the condition we are in. So let us, at the same time, we cannot say that, we don't know the species. Everybody are trying what this species is. So let me see that the digital revolution has transformed in the last few decades or couple of decades every aspect of human life, be it communication, be it the larger economy, even politics, and even our sense of identity. But with every kind of change, it poses challenge. The jurisprudence of human rights, traditionally grounded in the notions of liberty, dignity, and equality, now adds new questions of privacy, free speech, access, and algorithmic fairness. As I was pointing out, that in a way, history is a bit of a constant, from what I call as Flintstones to genetic clones. The whole question of such technological advancement has one central question of how legal systems are viewing this and how they try to shape successfully or unsuccessfully. And that is the point. Often one can reduce this to another level of, phrase, what I call as if. Why is a central question for a science person. Why is a central question every science person starts thinking. How is a central question for a technologist in terms of to get this science to operational way for human beings. For the lawyer or a person from the legal background, the question is not more than why and how, for whom. That is the central perspective of people who are in legal system, who are intertwined with human rights and many of these aspects. So we should now also highlight how these digital technologies are reshaping the understanding and enforcement of the human rights, which is fragile, but very assiduously it was being developed over the last few decades by innumerable number of thought leaders, activists, public policy wongs, and those who care for a better and fair world. So if I look at human rights in the digital era, we all know that the one which we quote often, the Universal Declaration of Human Rights of 1948, probably in its wildest imagination, did not anticipate social media, artificial intelligence or data surveillance. Yet, its principles remain relevant even after 70 years. Article 19, freedom of expression, and Article 12 on privacy, and Article 21, participation in public affairs, now acquire new dimensions and needs to be extrapolated or interpolated along with the happenings in the cyberspace. But even in 2012, the UN Human Rights Council resolution affirmed that the rights of the people which they have offline must also be protected online, was the first kind of definition which they wanted to enter into this brave new world called online, which has come due to the technological revolution. It is a landmark kind of resolution in digital jurisprudence. From there, one should analyze, with that lens, we should analyze what is happening. So if I really look very interesting, the space I come from, India, which you all know that has a parliamentary democracy, and as its foundation from British India, the constitution, but it is not British as such. As you know, Britain doesn't have a written constitution. India's constitution, in my opinion, is one of the constitution which was ahead of its times in many ways. A lot of homework had gone through in the Constituent Assembly, and where they looked at the best happenings around the world, they picked up the what you call as best practices around the world in order to prepare a constitution which will also fit in a kind of a country which was highly challenging at that point of time, whether this country will really remain intact, will the country will meet the needs of aspiration of the people at that point of time. So with a lot of hiccups, with sometimes strong criticism at different points of time, constitutional experts or constitutional researchers will agree that India could rise to many challenges and response. So one of the response which we really discuss as part of today's discourse is about surveillance, that or otherwise privacy, and where it was interestingly a retired judge, Mr. K.S. Puttaswamy, filed the very first challenge he mounted in the court against the government, that is Union of India, in 2017. It was very interestingly, very innocuous, ID card which was being introduced, which had all fine, what you call as arguments from a technology point of view. Anybody with a very brief, superficial way we look at it, it's excellent for a burgeoning population, and that's a kind of ID could help leakage of very many welfare schemes, and the government can really directly reach, is what vast majority would think. But a retired judge thought the other way. So he did challenge that particular ID scheme which was brought called Aadhaar, where it was made compulsory. So when he challenged, it was one of the very, very modern way of looking at constitutional issue rather than very traditional matters which has been there in different parts of the world, also argued in the Supreme Court of India. And this one led to a very, very, very path-breaking judgment where it said privacy is a fundamental right. Even though it is not written at that point of time, because they don't know these developments, but the court could interpret that privacy as a fundamental right. This judgment is seminal in the digital age in Indian context and makes a lot of relevance in other jurisdictions, because open societies, democratic societies do pick up the kind of logic and the arguments from each other's jurisdiction. So this judgment in India, where governments and corporations who track individuals through biometric data, social media and algorithms, there was this wake-up call that privacy as a fundamental right. Much before we know that Edward Snowden's revelations in 2013 about mass surveillance by the national security agencies showed the global states. The human rights jurisprudence now need to balance national security with individual liberty in an era of big data. So one of the justice Subbarao in one of the case called Karak Singh versus State of Uttar Pradesh in 1962. I'm not talking after the advent of internet and other things. At that point of time, very interestingly, he made an observation as a statement in the case. He said, privacy is the right to be left alone. This was, in my opinion, a great foresight by a justice called Justice Subbarao. In that case, he pronounced privacy is the right to be left alone. Anyway, today it has assumed a more complex way of dealing, and that found resonance in terms of the fundamental right principle which was enunciated, which Puttaswamy's case has been played out in India in many, many times from human rights perspective, from individual liberty, in terms of data protection, in terms of many things. This case has been now etched in terms of the law books. So this is the first point. Then when I come to the freedom of speech in the digital age, no doubt the internet has democratized speech. Twitter, Instagram, or YouTube have given voice to the marginalized. Yet, hate speech, fake news, and online harassment test the boundaries of the various articles. In India, we have an article 19(1)(a) which deals with freedom of speech and expression, of course, with certain kind of restrictions. And there, the whole thing is being played out that is freedom of expression also gives unfettered visa for hate speech, fake news, or other harassments. This again, very interesting. Like a retired judge, there was a third-year law student, Shreya Singhal, when she filed a case with Union of India at that point of time in 2015, when the government introduced amendments to the Information Technology Act, they introduced one section called 66A. And in the 66A of the Information Technology Act, they had several, terms, and which includes annoyance, all that telling that in that case, one can act and stop such freedom of expression. So, but the Supreme Court had a different view, challenged by the student in section 66A of the Indian IT Act, which recognized that vague restrictions on online speech violate constitutional freedoms. This case affirms that digital speech deserves protection as much as traditional speech. So even though people were concerned about transgression and many things, but the antidote for that is not a sweeping shutdown of the speech in the cyberspace by those in the power, and they are the one who normally more concerned or criticize. So when they introduce this section 66A, which you can refer and the struck down provision in the internet, you will see the court pronounced that this particular section needs to be removed. And that, in our opinion, when we talk the connecting dots of the digital age, human rights, and then other paradoxes, this becomes a very important part. So the jurisprudence now must grapple with deplatforming, algorithmic amplification, and private platform governance. These are the other challenges which are emerging now, raising questions. Who decides the limit of free speech? Is it the state? Is it the courts? Or is it the private tech companies? Who decides is a complex question which cannot have a simple answer, which can also have a complex answer. But nevertheless, as I said, the hallmark of any open societies or democracy in progress needs to grapple with such complex questions and try to come out with answers which might answer such complexity. So the next point in that particular line of thinking of digital jurisprudence, what is happening, which is impacting human rights and other issues, I would call it equality and non-discrimination. Algorithms, often presented as a neutral kind of phenomena, can embed bias. Artificial intelligence, we are now looking into the patterns of hiring, predictive policing, or even loan approvals may perpetuate discrimination against those who are weak, those who don't have representation, or even in third world, often we call it as marginalized communities. So marginalized communities have been a traditional marking, but even non-marginalized communities, as I said, as an individuals who lack the economic or other support systems could also lose out in this juggernaut of the new technology moving in, which is also a concern for the human rights jurisprudence. The European Court of Human Rights has also warned that the new technologies can reinforce structural inequalities. For instance, fiscal recognition systems disproportionately misidentify minorities. Challenging article in India, it is Article 14, which talks about such equality which cannot be, inequality which cannot be practiced. So, in one of the former popular Chief Justice of India, Mr. Chandrachud, he noted in a case called Naute Johar versus Union of India in 2018, a celebrated case, he said the statement, constitutional morality requires that rights be inclusive. So there's a huge debate runs. What is constitutional morality? Can we come to a consensus? Keeping the debate apart, it has been reaffirmed that inclusivity is part of a characteristic of constitutional morality, and hence the digital space too must respect inclusivity is the takeaway from this type of judgments. So then if I move to access to internet as my kind of last part of my talk in one sense is, during the Kashmir problems a year back, there was an internet shutdown which happened in the entire state. There, a case called Anuradha Bashir versus Union of India in 2020, the Supreme Court held that the freedom of speech and trade through the internet is protected under Article 19. So the argument is, whatever articles written 60, 70 years back was written with a different perspective of speech in terms of, physical, pronunciation or at the best, speech done through newspapers and things like that. But internet was much, much distant. But these court again affirmed, as you all know, precedence of the court cases is now part of every law. And so under Article 19, they pronounced that speech and trade through internet is protected. While the judgment did not declare internet access as a fundamental right, but it recognized the centrality in exercising constitutional freedoms. So globally, we all know that countries like Finland have declared broadband access as a legal right. The UN General Assembly in 2016 also affirmed that disconnecting people from the internet is a human right violation. So we are, as we said, that the merger of offline and online has happened in national level, lawmaking to international level declaration. Is it the violations happening with impunity? That's another part of the story. As of all we know, people who are legal researchers, people who want things to run through a legally designed way, at least we'll try to hang with these type of declarations or further enlargement of rights. So the emerging frontiers, as I said, data protection. India also introduced a Digital Personal Data Protection Act in 2023. And AI governance, the more quoted one is the EU AI Act, which regulates high risk, setting global precedents to many countries. Human rights law must now answer Can machines be biased? Who is liable when AI makes decisions? And this is now entering into the central debate of human rights or connectivity paradox. So, as I pointed out, even gender rights has now become part of this discourse, where online gender-based violence is rampant. And in India, there is a famous celebrated case, much older, called the Vishaka versus State of Rajasthan. It laid down workplace protection, but the digital workplace protection was not laid and needs now more updated safeguards, which increasingly people are fighting that people could escape the old law in terms of online harassment. Internationally, the CEDAW committee has urged the states to address cyber harassment as a form of gender things. So, if you really look, what the way forward in one way is rights-based tech design, that is embedding human rights impact assessments in digital platforms. Second could be judicial innovation. Courts must adopt doctrines to keep pace with AI, deepfakes, and surveillance capitalism, and international cooperation. Human rights jurisprudence, the digital age cannot remain bounded by national border, because in the world of internet, actually speaking, the Marxian concept, the state will wither away, has actually happened in the world of internet, right? So it is very crucial that this is not a national question. It is a question of international push and international thing. So it is very, very important at this point of time to look at it. And I may add one point which I want to talk about is the connectivity paradox, which has been mentioned for me to touch upon. I will say a few minutes, 5 minutes maybe on that, and then I will interact if there is some interaction. As I said, first glance, digital connectivity appears to reduce inequality. Billions of people now possess smartphone and internet access. However, access to digital platforms does not automatically translate such ownership as a technological power. And this is the essence of connectivity paradox. At least I would say 3 features illustrate this paradox. First, data flows are asymmetrical. Large volumes of data are generated in developing societies through digital platforms, and the processing, monetization, and patenting of this data often occurs in technologically advanced economies. That is the first point. As one observer put it, when knowledge travels north as data and returns to south as patents, intellectual property becomes a new form of extraction. This needs to be kept in mind when we are really talking about the connectivity paradox, or this conundrum of technological advancement and disempowerment of the individual on the other side. Second, many societies generate remarkable innovation, but lack the institutional framework necessary to own them and scale them as innovation. Post-colonial societies did not lack creativity or ingenuity. Rather, they often lack access to capital, the intellectual property infrastructure, and innovation ecosystems. So this is one of the crucial concerns if we are to analyze this connectivity paradox. Third is digital connectivity increasingly occurs within surveillance architectures. Governments and private corporations possess unprecedented capacities to monitor digital behavior. So the legal challenge, I would share at least 3 crucial areas: cyber access, national security, and right to privacy. So this is very, very crucially is the one which we have to take it. So for many countries in the global south, intellectual property harmonization means adapting global rules without equal participation in ecosystems. So for the global south, harmonization in IP has often meant as what I call as inheriting rules without inheriting power. So I will close my closing remarks with the following few what I call as bottom line things to consider. First, digital access should increasingly recognized as a basic infrastructural right comparable to electricity or roads. Second, societies should or must invest in inclusive innovation system, strengthening public research funding in universities. And third, the IP systems must evolve to support equitable participation in the knowledge economy. And finally, cyber regulation must ensure that the digital governance does not undermine freedom of expression or privacy rights. So this is very, very crucial. Why I say that apparently what looks in front as a big gain may have a different story to tell. As they say, in the 19th century, when first railways were introduced in many parts of the world, they were celebrated as symbols of progress. Even today, railways connected cities, expanded markets, accelerated economic growth. But historians later observed something very interesting. The railway lines often connected ports to resource regions, ensuring raw materials would move efficiently to imperial markets. The infrastructure created connectivity, but the structure of that connectivity determined who benefited from that. So connectivity alone does not create guarantee justice. What matters is who designs the system, who owns the infrastructure, and who captures the value generated should be part of the discourse. Without that, it could be a myopic thing. So let me close my last sentence of my thought process. As I said that we have to step back and observe the arc of human history, where a pattern becomes visible. Every major technological revolution has altered dominant resource of economic power so far, and will be try to have a different type of alteration where it will be more equitable and fair. So this is my closing remark, and let me thank the organizers at this point for giving me an opportunity to share my thoughts. Thank you.
Thank you very much, Professor. Now, I'm conscious of our time, but I will take some questions if there are any.
Thank you for your speech. That's very insightful. I had a question. As you are the Vice Chancellor of a very highly rated law university in India, and in India, National Law Universities, students coming through the CLAT examination. So, in your role as the Vice Chancellor and as an educator, have you seen these new AI developments and the rapid AI developments? Has it helped students from marginalized communities to gain access or gain a foot into a space that they were previously excluded from? Or have you noticed that they have been pushed further away?
Adil, one issue is I'm getting a bit of kind of an echo and accent. Is this question typed in the chat box or is it just a oral question?
It's an oral question from the audience. So
okay, I understand because I think they are not sitting in the laptop; they are just in a hall or something. So can you repeat the crux of the question? I'm trying to.
Yeah. So the question is, as your role as the Vice Chancellor, have you noticed the new AI developments helping students from marginalized communities to gain access or a foot into a space that they were previously excluded from, or have they been pushed further away?
Okay. If I'm not exactly got, but I'm able to get the sense of the question talking to me as head of the institution about students and AI and what is happening. Am I right? Is that the question about AI and in the educational institution and students?
We have typed the question into the chat box. You can.
Okay. And now I will just see that. This is much easier, so I can precisely, you are the co-chancellor of university. Through that brings students in this role of yours. Have you seen AI developments help students from marginal economy gain access to food in the space that they are previously excluded or have been pushed even further. See, I don't know whether the student also has a fairly good understanding of all of the others who may not know this. We have a common law admission test. This is only for the national law universities we call, which is around 25 now in our fold of the consortium. And only for them, it is done for about 4,000 seats of that. And let me first tell you, we, as public law schools, first of all, there is a marginalized community definition, is a historical definition of what you call backward classes, scheduled caste, scheduled tribe. All these three have what I call as quota systems, where the other people cannot come in. So there is, for example, and that also differs from sometimes state. The state I come from, where my law school is located, in fact, has around 52%, which is reserved to the marginalized community, which cannot be given to others. So it is a constitutional intervention, not an individual school or consortium doing it. This is across the board we have. Apart from that, we have other reservation. When you use the word marginalized, for example, for people with specially abled, we call it, or the old term disabled, also has got a quota system. Then there are supernumerary quotas for displaced people from troubled regions like Jammu and Kashmir. There is also some level of recognition of freedom fighters, 1 or 2 seats. So I would say fairly there is a legal, intervention which is coming. But secondly, the question, if I have to answer properly, how far the entry system is fair enough to all sections, I would say that there has been a strong understanding, demand, and problem that the class system favors more urban English-speaking people with certain level of background. And for those from the rural districts who cannot have the access to coaching centers, etc., certainly don't find a way apart from this so-called percentage, what I said. So let us say 100% and 100 seats are there with different law schools. You may have around 40 people from marginalized community. We call it as structurally called as marginalized community. In the remaining, there can be a person who are not part of that, but they are doing. So this is a question which we are trying to address in a mass question like this. It has been so far a kind of a FAQ type. There has been demand to move towards certain other types, but again we have other problems of language issues. There has been a strong court cases happening to have it in multiple languages, and still the consortium has not come to a conclusion. There's committees which are studying whether getting it into your mother tongue, will it actually help certain marginalized people to easily understand? Because otherwise, those who don't speak English or never had an English background school are marginalized in one way. So these are all last 2-3 years we have been, what you call as putting it. No clear answers are there. There are 2-3 committees working, including an advisory committee with the Attorney General as well as a retired Supreme Court judge are looking into that. I do understand that a couple of national law school students who are teachers, one at least a teacher in UK, one is in US, all of them also been drafted to prepare a kind of entry level, entry barriers to be reduced for this. This is my answer. AI as such not entered as such into our, exam systems.
Okay, so quickly, we have one question from the audience, so I'm going to read it out loud. Intellectual property rights are generally not a human right. However, with generative AI, we are seeing gross violation of intellectual property rights through data scraping, leading to a loss of creative expression and distortion of traditional art. Can you tell us a bit about how this particular interaction of IP and AI affects the social and cultural rights of communities?
I'm just looking. Is it appearing in the screen? The question? Yeah. Generally, not a human right. However, with generative AI, we are seeing gross violations of intellectual property through data scraping, leading to loss of creative expression and distortion of traditional art. Okay, first statement, it is not a human. We all know intellectual property is a private right of incentivization, but I would not sweepingly tell it is not part of human right. Because there has been a strong movement within IP, what we call a development agenda, which even WIPO tried to push 2 decades back, which did not find much resonance because there are not much takers. And there are questions of genetically modified stuff. There are questions of traditional knowledge. All that will certainly come within the discourse of human right, in my opinion, has been involved with IP for a long time. So the first question, what you say, is not it is not deliberately kept out of human right. My opinion, it is part of human right. Vaccines are part of human right, which we saw biggest issue in the COVID time. So in fact, it brought the centrality of human right into the discourse, especially in COVID time. Okay, leave that apart. But I have said that generative AI, we are seeing gross violations of IP. So yes, the point is copy left is one thing, copyright is one thing. So the battle sometimes is between big investors who are talking about certain things and using data for machine learning. All that cases are going on now. As far as other things are concerned, whether the general public or the individual user, are they violating IPR? Yes, naturally, when big corporations can have a different take on how do they develop their AI machine learning systems using data sets, individuals will also be part of that because they are into the same phrases they are doing individually. The individual violation may not be really causing big harm, but large corporations who are into a different take now, as I said, not the traditional IP vanguard, I call it, as software companies or other platforms, but the new machine learning people who have come, OpenAI or Anthropic and other people who are coming inside, they have a different take on that. So, in my opinion, as I said, social and cultural rights, IP impacts sometimes excluding people because that is one. Other side, somebody may argue it helps to find better markets for others for many things. For example, GI. GI, people say widely, has helped a lot of communities in different parts, especially in India. There's a big welcome for GI because otherwise communities which have abandoned their thing has now been streamlined. So it's a kind of a complex question. Question is, how far IP? Should IP there or not? That question nobody asks now because some form of IP is functioning everywhere in these areas of traditional arts. But how far that should go, as I said, that at this point it's being debated. Even WIPO took many decades to work on traditional knowledge, where your traditional art comes. And they've come to some conclusion which is also widely criticized now. And we have to wait and see how it unfolds.
Right. Thank you very much. I'm conscious of the time is running out. So thank you, Professor, for your insightful talk and a very active Q&A session. I think the first part, you gave us a very important perspective by putting the discussion around emerging tech in a bigger historical picture. And then we were fortunate enough to give in the context of a very insightful jurisprudence of Indian courts, which I think a very important aspect to look at in understanding the issue from global South context. So thank you very much again for your talk, Professor. And I think your talk most definitely given us plenty of insights for us to expand our studies on this topic. So can we get a round of applause again? So now we move on to closing remarks of tonight's session. So thank you very much, Professor. I'm going to hand the mic over to my colleague here.
Thank you so much. So we had a really fruitful day today with 2 panels and a speaker before both of them. Thank you so much for everyone who tuned in to was part of our session and who wanted to learn a bit more about human rights in Asia, specifically in issues related to the to gender issues and also to the digital divide. So far, we learned that AI is exacerbating structural issues in our communities. The problems are not created by AI, but could be more visible or could increase due to the misuse of it. We've seen how these tools have been fruitful for some debates, but can also be prejudicial for the rights of others if they are not used in the correct way. It's been really interesting that throughout our day, some of our speakers have talked about how first this divide is not only due to economic reasons or due to socio-economic reasons, but also because of the standing of these people in their country due to gender, due to age, and many other factors. We also saw some specific cases from countries in the global south, also from countries in Southeast Asia, East Asia, and it's been really interesting to see how these or our speakers are helping to close this divide or to actually activate the conversations and help people in their countries and in all around Asia. So with this in mind, we really, from the Human Rights Center in the University of Essex, we want to thank everyone who came today and thank our speakers for introducing more people into these discussions and helping us learn even more about it. And with that, we close the first day of the session in the Human Rights in Asia conference. We hope to see you in our second day in 11 March when we're going to have the screening of a movie that is also evidences some of these discussions and some of the issues we're currently facing. And we hope to see you too on our third day on March 14 to continue with two other panels that are going to be as equally interesting as the both we had today. So thank you so much and hope to see you soon.
Thank you. Thank you.